President Hlophe, we were talking about the role you would play as Chief Justice that no other judge could play if you were appointed. You were still talking about judgments pre-1994, which you say, I think if I understood you correctly, are of no value.
They are of limited
in the constitutional
value. Yes.
Can you elaborate on this?
Well, they are of limited value because they were based on a totally different legal system. Before 1994, we had apartheid in place and no constitutional dispensation, as you and I understand it. Black people had no franchise. So our culture, our aspirations, our expectations were not reflected in that legal system. Then came 1994 with new ethos, with new values encapsulated in the Constitution. That to me must be the basis going forward. Take the Constitution, concentrate on that, and build and create a new legal system founded on the values of equality, non-sexism, no discrimination, and supremacy before the law. Rather than taking common law and say, what is the best we can get out of this? No. I look at it in a totally different manner. Create a new culture of human rights. If I'm correct in what I'm saying, there should be no debate about, for instance, whether or not to recognize African customary marriages, whether or not to recognize Muslim marriages. You would know there is still even a case in the Constitutional Court on whether or not Muslim marriages must be recognized. If you said equality is a starting point, therefore whether you are married according to Muslim rights, African rights, or Jewish rights, it's neither here nor there because the starting point is the supremacy of the Constitution.
Now, you're not saying all law. I just want to clear this up. You're not saying all law before, all case law before 1994 must be thrown out.
No, that's not what I'm saying. But I'm saying the cases before 1994, when we look at them for guidance, we must know they were decided before 1994, and the judges that presided over those cases did not have the wisdom and the kind of constitutional guidance that we find in the new constitutional dispensation. Yeah. They were serving different masters. We are serving a different master. It is the new constitution and the new South Africa. There's a big difference.
But JP, doesn't it depend on the area of law?
Yes, you are right, granted. Yes, granted.
Because, for example, there's in contract law, there's this principle of which you are aware, the Susfield versus Bierkes thing in sanctity of contract and so on.
I agree with that.
And recently, the Constitutional Court has just affirmed that that principle is still part of our law, but now it has to be imbued with a sense of constitutionalism in this Biadika judgment.
Yes, I'm aware of that. So I agree with you, Mr. Ngalwana. You're absolutely right. It depends on the area of the law. Yes. But I'm saying let us be careful. We're not going to get guidance from pre-1994 judges as to how to interpret a Bill of Rights in the Constitution. We're not going to get much guidance from them. How do you interpret a Bill of Rights? Look to the Constitution and look at jurisprudence after 1994, not before 1994. The Constitution did not exist. And a lot of those judges, if not all of them, were vehemently opposed to the new constitutional dispensation anyway.
Would it have another controversial subject? If you had an influence in what happened at the Truth and Reconciliation Commission regarding, because you remember big business and the judiciary were also invited to
Judiciary declined.
Yes, and the judiciary wouldn't have any part of that. Now, some people take the view, I don't know whether they're in the majority or the minority, but some people take the view that that was a mistake for the judiciary not to have taken that opportunity to make a clean breast of what their role was in perpetuating apartheid.
Mr. Ngalwana, I agree with that view wholeheartedly. Apartheid judges missed, in my view, a golden opportunity to repent, come forward, come clean, and admit the dirty role that they played in ensuring that apartheid was created and that it survived for 50 years or so. They refuse. In my view, they missed a golden opportunity to embrace the changes that we have and be part of this new dispensation and be part of the constitutional culture that we have. They missed that.
And seek amnesty for their role?
Well, instead they denied their wrongdoing. We all know the role that apartheid judges played, not only in creating apartheid, but in maintaining it for centuries. Apartheid was maintained by judges. Any legislation is a skeleton, but the flesh in any legislation is always put by the judiciary. That's why, sorry, I'm reminded, for instance, there is an old case that I like to quote, Lockhart versus Minister of the Interior, as a judgment of Holmes, J.A., who described the then Group Areas Act as a colossal social experiment which the legislature brought about and which envisaged forced removals of one population group from one area to another. This is a judge saying that. He basically said to the apartheid regime, here is a blank check, enforce apartheid the way you want to develop it.
But let's be clear, especially for those who are lay in matters of law, that you're not saying every judge that was appointed or that served before 1994 was a quote-unquote apartheid judge, because there were some judges who were progressive.
It is very true, Mr. Ngalwana, you're right. They were very progressive judges, and we owe them a lot. Many have just mentioned Judge Ian Falam. Another judge who comes to mind is late now, John Didcott.
Yes, in Natal.
In Natal. But it does not detract from the fact that they were appointed by an illegitimate government. That is the bottom line. They may not have imposed the death sentences, they may have been liberal. South Africa is grateful to such judges, but the fact of the matter remains. They were appointed by an illegitimate government.
And for that reason, they should have applied to the
For
Amnesty
amnesty,
Commission.
yes. They should have applied. They missed a golden opportunity. If I were in their shoes, I would certainly have availed myself of an opportunity to go to the TRC and say, I, Ngalwana John Hlophe, I was appointed by an illegitimate government. I admit it was wrong of me to accept that, or I sentenced so many freedom fighters to death. I admit it was wrong. I was serving a different master altogether. But now I am prepared to embrace change. I'm prepared to embrace equality between sexes, between men and women. That's what I would have done if I were in their shoes. But there was another question, Mr. Ngalwana, you'll see how to put it. You asked me what will I introduce. The other thing that I forgot to mention.
Yeah, you mentioned two, there was a third.
The third one is this. I think I like when I write judgments, keep them short and simple. Especially judgments of the Constitutional Court. I find them unnecessarily scholarly, too long. Let's take State versus Ngalwana. I want judgments of the Constitutional Court to be simple because we are speaking to the masses. And the vast majority of our people are not only that they are not lawyers, but they are not educated. A judgment like State versus Ngalwana should not be more than 10 pages. Give us the history of the abuse of capital sentence in this country, that it was largely black people who were murdered by white judges, why that is unacceptable, why that should never happen again because of the doctrine of equality which we find in the Constitution. Keep it simple so that even a taxi driver who's driving a taxi in a bus rank would take State versus Ngalwana and say, yes, I understand it. It's a very long judgment, unnecessarily scholarly. There's a lot of reference to foreign law instead of concentrating. We should also show pride. This is probably the fourth point. I think there should be more reference to African jurisprudence. We've got lots of scholars in Africa, yet we fly in terms of our thinkings and land in London, Brussels, Paris. We don't look right across the border. How have Zimbabweans, for argument's sake, how has the people of Kenya How have the people of Nigeria, faced with similar circumstances, how have they reacted? I'm not against foreign law, but you must adapt it and not borrow unwisely. And we don't seem to have confidence in our own scholars in Africa, our own judges in Africa. We tend to borrow from Europe. We are too Eurocentric in our approach. I would prefer an approach which is more Afrocentric, which recognizes who we are as a people, where do we come from, and a clear sense of direction of where we are moving as a nation, and we need to fit ourselves not only into the region where we are, but into the entire continent and ultimately the world.
Perhaps, well, I don't know how he may view, this is former Deputy Chief Justice Museneke. He once wrote, maybe more than once, in a judgment that as South Africa we should be careful of importing precedents from other parts of the world, specifically the United States, on equality jurisprudence, because our history and the way we deal with things and our constitutions are different. And so we should do so very sparingly. So to some extent, and I'm saying I'm not sure whether he'll take this as a compliment or as a slight on him, when I say you and he on that point are to some extent on the same boat.
Well, I've always respected Justice Dikgang Moseneke, very bright, and I agree with that entirely. If he said that, I haven't read that, I agree with those sentiments entirely. We should not borrow unwisely. We should only borrow because it's necessary for us to borrow from foreign jurisprudence. Why is necessary? It does not exist in our constitution. It doesn't exist anywhere in our country. It doesn't exist in Africa. Then let's fly to Europe. But we don't fly to Europe in order to come back with a solution which has not been tried and tested elsewhere outside Europe, and then we borrow that blindly. We bring it to the African shores. It won't work.
All right. Thank you, Judge President. We'll wrap it up in the next segment on a few, perhaps not as controversial issues as some of the issues we've covered thus far.
All right.
Thank you.